Buckle up, folks. This isn't your average courtroom drama. It's a raw look at probable cause hearings in Harris County, Texas, where everyday folks face charges that could upend their lives. We got Mr. Walker hit with resisting arrest for simply walking down the street while possibly intoxicated. Mr. Martin charged with evading after loitering turns into a chase. Devin Shamlin detained over a quick car interaction mistaken for a drug deal. And Mr. Hardy pulled over for parking a bit too far from the curb, leading to a marijuana bust. The judge isn't buying all of it, calling out potential biases like walking while black and parking while black. Will justice prevail, or is this systemic overreach? Stick around as we dive into the twist, the dismissals, and the real stakes. You won't believe how these play out. All right, let's roll.
Let's roll, nerds.
Good morning, Your Honor.
Hey,
How's it going?
it's been a while. How are you? What's
All
new?
right. Yes. Let's guess.
I'm right. Thanks. Good morning, Mr. McGaskey. So you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. Mireles picked up a new case.
Yeah, and he came in, checked in, and left saying he had other places to go.
What?
I warned him that if he left, that more than likely a warrant will be issued for his arrest.
Next time,
I can't because I'm on that technique. That's part of the problem.
all right.
But I agree.
Mr. McGaskey, we're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Just please don't say it.
October 26th, officer was dispatched to a major crash in Harris County, Texas. Upon arrival, the officer observed the defendant sitting in the driver's seat of his motor vehicle with his keys in his lap and with an odor of an alcoholic beverage. The defendant stated he drank prior to driving. Standard field sobriety tests were performed. HGN 4 out of 6, walk and turn 4 out of 8, one leg stand 3 out of 4. The DIC was read and the defendant consented to breath, but the defendant was unable to do the test. A blood warrant was then signed and executed.
It was really quick. So where was he?
So it was a major crash in Harris County, Texas, specifically on 2201 Southwest Freeway.
Okay, and then what?
The officer arrived and he was in his driver's seat, and the officer observed his keys in his lap, and then he observed an odor of alcoholic beverage.
Just an odor. Anything else?
And then the defendant made a statement that he drank prior to driving.
Yeah.
And that's it.
Leads you to believe that he's drunk. We have an accident, I get it, but there's just an odor of alcohol. There's nothing, no slurred speech, no bloodshot eyes, just an odor.
Yes, sir. All that was written was the odor was observed, and then the statement made about him drinking.
McGaskey, I have an accident. All I have is an odor of alcohol. What can you, other than the accident, what can you lead me to believe that he's drunk or intoxicated?
The defendant stated he drank prior to driving.
We don't know how many, we don't know how much, we don't know when it was happened.
Well, Judge, I don't think that's necessary to provide probable cause for the case. He's admitting to drinking, he's got odor of alcohol in the breath, and the accident itself is evidence of intoxication, Judge. All of that, in our opinion, is enough for probable cause.
I don't think so. I mean, usually there's a lot more than just that. An odor, we don't have anything else. I don't know when, I don't know how many, I don't know how strong it is, just an odor.
Not every case has extrapolation or admissions of how many, Judge.
I understand. I understand, Michael, but I need just a little bit more than just an odor and an accident.
An admission to drinking, Judge?
Okay, we don't know when. The officer can't do any more questions than that. Okay, when did you do it? How many did you have? Did you have anything to eat?
Understood.
Yeah, all right, I'm going to find no probable cause, Mr. McGaskey. It's very possible if they take it to a grand jury and indict it, but so I would be on the lookout, number one. Number two, you know how many accidents and death we have every day due to alcohol and getting into a car? I'm going to find no probable cause. Just take a seat for a moment.
Thank you, Judge.
Thank you, Mr. Jeff. All right, Ms. Rodriguez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, Judge.
Okay.
The officer initiated a traffic stop after observing the defendant's vehicle traveling 94 miles per hour in a 65 mile per hour zone. The officer observed an odor of an alcoholic beverage, and the defendant admitted to the officer that she had 2 drinks. Standard field sobriety tests were conducted, HGN 4 out of 6, walk and turn 5 out of 8, one leg stand 2 out of 4. The DIC was read and breath was refused. A blood search warrant was signed and executed.
Felt like that went really fast. So the stop was for speeding.
For speeding, yes.
Then
And then after that, they had an odor of an alcoholic beverage, and she made an admission that she drank 2 beverages.
just an odor and admission of 2 beers. Any other indication of intoxication? I mean, slurred speech, bloodshot eyes.
I know that while the SFSTs were, this is for the gyms, while the SFSTs were being conducted, she was not understanding, like the officer.
Whoa! Hold up, did you catch that? The judge just dismantled this case like a house of cards. Devin Shamlin gets flagged for a 10-second car hop that screams quick chat with a buddy to most of us, but to this proactive task force, it's code for a drug deal. They spot a Starburst bag with 14 grams of what they claim is marijuana. That's about 0.49 ounces. Folks, hardly a kingpin haul. Legally, this hinges on reasonable suspicion for detention, but the judge calls no probable cause, highlighting how everyday actions can spiral into arrests without solid evidence. It's a classic overreach, echoing the judge's own high school anecdotes. Talk about hypocrisy in policing. One quick interaction, and boom, you're detained. Who do you think is right here? The task force spotting patterns or the judge seeing bias? Would you hop in a car like that without worry? This dismissal reminds us of the thin line between suspicion and profiling. Stay tuned, because the next one's even wilder with a parking violation turning into a full search.
Explained, I think, at least 4 times the instructions for the walk and turn, the one leg stand. He also noticed that I think she took off her boots for the one leg stand. She was stumbling when she was taking them off. So there were other signs that the officer.
That's what I want. I mean, an odor, not even a strong odor at that, you know? And then you just have an admission of 2 beers. You don't know what time. Was it over a 12-hour span? You know, there's no accident here. There's no, is she a Spanish speaker?
I believe so, Your Honor.
I don't see any indication of that.
And if I may, I've been doing DWIs for 10 years and I don't understand the instructions most of the time.
As far as I can tell, the officer also just demonstrated it to her. I mean, which is per,
But I get the SFSTs, but I mean, to even get to the SFSTs, right? You have to show something that there's some indicia of intoxication. Here, all we have is an odor and admission of 2 beers. That's not enough. An odor of alcohol in and of itself is insufficient.
But
Yeah.
it seems that this stop occurred at 2 a.m. and she made a statement that she stopped drinking at 12 a.m. So we have a 2-hour period between when she's finished drinking and then
Alcohol dissipates every 1 hour. An alcoholic drink dissipates from your system.
she still had the odor in addition to that statement.
All right, I'm going to find no probable cause.
Yes, Judge.
Ma'am, be careful, really. Every single day, someone dies from a DWI in our county. It's so easy to take a $20 Uber, literally push one button. You have a car waiting for you wherever you want to go in this county. Do you understand?
Yes, sir.
All right, please take a seat. You are Keon Shaw.
Yes, sir.
Mr. Shaw, you're charged with fleeing a police officer. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On October 27, 2024, the officer was conducting a routine patrol on Eldridge Parkway when he noticed the defendant's motor vehicle traveling at an unsafe speed, exceeding the posted 35 mile per hour zone. The vehicle then began driving in a suspicious manner by making a sudden left turn on the street and immediately parking on the left side of the road. When the vehicle noticed the officer's fully marked patrol vehicle passing, it immediately conducted a U-turn and got back on the main road. When the officer continued to follow the defendant's vehicle, the vehicle again conducted a left turn and pulled into an alleyway. When the officer initiated his emergency equipment in an attempt to conduct a traffic stop, the defendant's motor vehicle passed multiple safe stopping points before finally coming to a stop after traveling 0.5 miles through a dark and empty parking lot.
What was he doing wrong?
According to the officer, he was originally traveling at an unsafe speed, exceeding the speed limit, 35 miles. He was exceeding that speed limit.
By how much?
Let me see the DIMS if he specified. Your Honor, he did not specify. It was just an unsafe speed exceeding the limit. And then
Nothing's unsafe to me.
And then he began driving, according to the officer, in a suspicious manner, making sudden turns and then stopping on the side of the road and then getting back on the road once the officer passed. So
Anything illegal with that? You know,
I believe it would just be the speed limit would be the point at which the officer.
it's a conclusory statement. We need to have like a workshop on how to write ORs, man, for real. You know, everything in this office report is conclusory, suspicious, aloysius. You know, is he driving while black?
Judge, would you allow us just a few minutes to call the officer just to see? We don't have an OR. We're just going off of the.
Sure.
DIMS.
Let's do this. I'm going to have them because I want to make sure if we find probable cause that it's really there. All right. So just hang tight for me. We're going to have to do a little deeper dive. If you just mind taking a seat for me momentarily. Okay. Okay. Don't leave, Mr. Shaw. Okay. Who's next? Jaramillo Jimenez? You were charged with driving while intoxicated. You were facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford.
Boom! Another no probable cause ruling that hits like a plot twist. Mr. Hardy gets dinged for parking over 18 inches from the curb at 4:30 a.m. per Texas Transportation Code Section 545.303, which mandates parking within that limit to avoid obstructing traffic. But here's the drama. The officer runs the plates. A female passenger approaches smelling of weed, leading to a vehicle search uncovering 54 grams, 1.9 ounces, of marijuana in various packages, plus a burnt cigar. Financially, he's facing up to 6 months jail and $2,000 fine, but the judge skewers the initial stop as parking while black, questioning the odor justification and timeline. This exposes hypocrisy. Why escalate a minor parking issue into a full narcotics probe? It's emotional, with the judge urging life improvements amid systemic pressures. Viewers, would you challenge a cop over a 1.5 foot parking gap? Or is this smart policing? This transition sets up the bigger picture. Repeated dismissals highlighting potential racial profiling in routine stops. Don't miss the wrap-up.
Ward one will be appointed to you, sir.
On October 28, 2024, officers conducted a traffic stop on the defendant's motor vehicle after observing it operate without all of its lighting equipment activated during the nighttime. Upon contact with the defendant, who is the driver and sole occupant, officers observed the suspect to have slurred speech, bloodshot eyes, and an odor of alcoholic beverage. Defendant admitted to drinking 2 alcoholic beverages about 1 to 2 hours prior. SFSTs were conducted, 6 out of 6 HGM, 7 out of 8 walk and turn, 2 out of 4 one-leg stand. DICs were read, but breath was refused, and a search warrant was signed and executed. The defendant does also not have an eligible driver's license, Judge.
Again, we have to go on an offense writing report.
Hours prior. SFSTs were conducted, 6 out of 6 HGM, 7 out of 8 walk and turn, 2 out of 4 one-leg stand. DICs were read, but breath was refused, and a search warrant was signed and executed. The defendant does also not have an eligible driver's license, Judge.
Again, we have to go on an offense writing report, just class. I mean, it's completely conclusory. Read me the first sentence. Why the PC for the stop?
Read from the DIMS really quickly, Judge. I just want to make sure it's correct. And then
Without all of its nighttime equipment on. What on earth does that mean?
see if we can read it from if we have the offense report, Judge, because that's what
It's
it is.
over and over and over and over. I mean,
Bicycle or a car?
headlights, brake lights, turn lights.
Fog lamps. My favorite kind of light.
I'm just seeing in the offense report, Judge, that driving without lights activated during nighttime.
Better. So you're saying he was driving at night without headlights? Is that?
That's what I believe this offense report is stating. It doesn't specify which lights, unfortunately.
I mean,
Would you like us to call Officer Judge to clarify?
yeah, I guess I'll give you a bit of time for, just toma asiento allá, por favor.
Wrapping this up professionally, in these Harris County probable cause hearings, we saw Mr. Walker dismissed for resisting arrest tied to walking the road. Mr. Martin held for evading after loitering escalated. Devin Shamlin freed from a marijuana possession charge over a brief car interaction. And Mr. Hardy released from another pop bus sparked by a parking violation. The judge consistently found no probable cause in 3 cases, emphasizing biases like walking while black and questioning police overreach in minor infractions leading to searches. Broader implications? This underscores a need for stricter reasonable suspicion standards to prevent discriminatory policing, potentially reducing wrongful arrests and